You're on bond for this DWI. You've been on bond since 2019, and now you've picked up a couple felonies out of state. I don't want you to talk about the case. My only concern is while you're on bond in this case, you're supposed to behave yourself. You're not supposed to pick up any new cases, and you picked up a couple felonies out of another state. Are we supposed to reward you for picking up new cases? What else has he done, Ms. Sigler, since 2019? Two cases? One case?
I believe it was just one case from October.
Why should I not revoke his bond and put him in jail now? He's on bond for this case. He's been on bond and he now picked up a felony in another state.
And I do understand that, Your Honor. I think that just in the interest of justice, I think that given the facts, and obviously we're not here to discuss what's going on in Louisiana.
Are you representing him in Louisiana?
I'm not, no, Your Honor, I'm not representing him in Louisiana, but obviously I'm in contact with counsel there. I think, without getting into the details of that, Your Honor, I think it's an extraordinarily interesting law that they have, or laws that they have in Louisiana, where what we would consider as a technical civil dispute somehow gets transformed into a criminal matter in Louisiana. Obviously, the French civil law, I don't even attempt to try to understand those rules, but it is more of a civil dispute more than some type of fraud that was taking place in this situation. I think we're very optimistic that that's going to get resolved. Obviously, I've just been on this matter, Your Honor, focusing in on the CWI matter, Your Honor. It was a crash, but the facts as set forth in the incident report, Your Honor, he did not collide with another vehicle. He didn't hit a pole. He didn't hit a tree. Instead, based upon the report, he swerved to avoid another car coming out of a private driveway. So to avoid from hitting that vehicle, he swerved, hit a curb, which resulted in blowing out the tire on his vehicle. The car had other people in the car, and obviously that creates some issues, as Your Honor could imagine. But this was not a DWI case where he's driving down the road 60 miles an hour and crashes into someone or anything in that realm, Your Honor. So for those reasons, I think in the interest of justice, having him to go to jail, not that that's what's on the table right now, but having
it is on the table now, because he picked up a felony case while he's on bond for a case, right? He's been MIA for 5 years, and now you want some kind of in the interest of justice. The interest of justice is that we protect our county. You're on bond for this case. You've been on bond for 5 years. You've been gone. Now you pick up a felony case. Are we supposed to pat you on the back? No, I'm revoking your bond. I'm taking you into custody. What are we supposed to do? You know, you can't just be gone and then you pick up a felony case in another state. I mean, what are we supposed to do? You know? Really? But you have to understand that actions have consequences, right? You're an adult. Your failure to act, your failure to come, you're picking up a new case. Now, I know that you say it's a civil dispute, but they found enough probable cause and a grand jury indicted you. That's usually between 9 to 12 people that sit, have completely neutral and detached, sit, listen to facts and determine, hey, we think this person may have committed a felony offense.
Which was original arrest warrant, and it's still, the DA still hasn't accepted charges.
And we are, again, not getting into the details, and it's not, we're not here to try to resolve the Louisiana.
I get it, but
I'm sorry.
Go ahead.
No, and I'm just, let me suggest it. What happens in Louisiana is this. There is a civil dispute between the parties, what we would call a civil dispute. And as a result, in Texas, what we would do in the event if a contractor or subcontractor are not paid, we place a lien on someone's property. In Louisiana, if that same transaction happens, the homeowner, now obviously there would be consequences, there may be consequences for that homeowner, can call the DA and say, no, this guy ripped me off. Notwithstanding the fact they owe him money, this guy ripped me off. And if the DA there,
because I've had 2 people that have done that to me.
Well, Your Honor, over there, that it turns into a criminal matter. So again, we think it's going to get wiped away. I know we are this close to getting this matter resolved. And I think in all respect to the court, all respect to the bench, Your Honor, not being here for 5 years is a major issue. This matter should have been resolved a long time ago. Had I been brought in 6 months ago, it would have been resolved 6 months ago, Your Honor. We're just asking that, one, if there could be a level of grace and mercy extended to Mr. Williams at this today, I think we could get the matter resolved today, Your Honor. Obviously, I haven't had an opportunity to look at the medical records. I haven't had more than 30 minutes to even examine the record.
And you know, I'm sorry that you're being placed into this precarious position now. And the facts are what they are, right? If we could make our own facts, we would all win. But at times, the bill comes due. That is today. But if you think that you can just continue to get away, jump 5 years, come back, and while you're out there, you pick up a felony case as well, I can't because I would be telling you that behavior is okay, and it's not. If you guys are able to, work something out, by all means, I'm okay with that. But I can't in good conscience, when he's been gone for 5 years, he picked up a felony, whether it's in Abu Dhabi, whether it's in Alabama, Oklahoma, he's hopscotching states, but he goes with you. If you want to work something out, I'm happy to whatever you guys want to do, but it's only fair, really. But like I said, if you guys work something out, I'm happy to entertain whatever you guys want to do. But you guys talk, don't
Understand.
not here. He's going to take him back. I'm going to let you guys talk, see what you want to do. I'm all ears. I'm always open to anything else. But the bill comes due. All right. Take your time. There's no rush. I'm not going to continue to play this game with you. Mr. Castro, I'm not doing this again.
Sir.
Look at me.
Sir.
I have people that continue to come back over and over and over, and I want you to look at me, because this is going to be a life-changing moment for you right now. They keep coming back, they keep pleading guilty, they keep coming back, they keep pleading guilty, and it's a revolving door. The door stops today. Do you understand?
Yes, sir.
If you are unable to not pick up cases, then we are going to delve deep next time as to why it continues to happen. If that means putting you in a rehab facility, in a dual diagnosis residential facility for figuring out mentally why these things keep happening, then so be it. The door stops today.
Yes, sir. Yes, sir.
Do you understand, Mr. Castro? I know you well. And in the last 2 to 3 years, we're working at least. Since you and I have been together, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 stops today. If you are unable to exercise self-control, we are going to dance a lot together next time. Do you hear me?
Yes, sir. Yes, sir.
Hear me loud and hear me clear, Mr. Castro, because I'm not doing this again. we will have issues next time. Do you understand?
Yes, yes.
You now stand charged with theft. Hey, how many is this anyways? Is the next one a felony regardless?
I don't believe so, Judge, actually.
That's Judge.
Can you run an NCIC for me, please, Morgan? Let's take a look to see. 'Cause I want to advise him properly as to, you need to understand that every time you plead guilty to an offense, it goes on your record. And when you pick up a certain type of offense consecutively and times, they can put it together and they can file a felony case on you, and you're looking at years instead of days. You now stand charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. They've offered you 6 days in jail credit for the 2. Any prior thefts, Morgan?
No, Judge, I'm not seeing any.
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Mr. Castro, I want the best thing for you, but it continues to happen. So somehow we're not getting through to you. And we need to get through to you so that you understand it's not okay to continue to pick up criminal cases. And in the few short years you and I have been together, we're now working 12 cases. This is not acceptable. What do we need to do to get it to stop?
Yes. But yes, I'm completely capable of these, and because it is so highly agreeable. So I'm on top of it myself as much as I would be able to. This place, it is interestingly confusing, but yes.
Well, let me tell you something. I have a couple people in here that have continued to come back. And what we have done is now have them in facilities trying to figure out why they cannot stop picking up criminal cases. I'm telling you, I've got probably about 4 or 5 individuals that have kept with me. You now are on my list. So heed this warning.
Yes.
Do you understand, Mr. Castro? How do you plead to the offense of theft? Guilty or not guilty?
Guilty, sir.
I will find you guilty. I will send you the agreement. Good luck to you, sir. All right, Josh.
Josh?
All right, Mr. McCollum, good morning, sir. Number 1, don't email me. That's not a good thing, man. Really, because I'm supposed to be neutral, detached. So I don't know what happens until if it goes to trial. So just,
I'll be there.
it's okay, but just from now on, all right? So you now stand charged. You picked up a terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. I don't know what happened in this case. I'm just now seeing it for the first time. All I know is that you're on bond for this case. For another case, now you picked up a new one. So let's go forward and.
Officers were dispatched to a residence in Harris County, Texas. Complaining witness showed officers text messages ranging from May 2024 to November 2024, where the defendant sent her photos of guns and threatened to shoot the complaining witness and their child. Defendant also stated he would shoot up her house and hoped that he would hit her and the child.
When is the statement that he was going to shoot up the house? Was that from May and that he's just investigating this? Because that's not a terroristic threat. But if it was an active thing where he was.
Well, it looks like the offense, so per the offense report, the actual offense took place on November 8th.
Okay.
But I believe that she showed them old text messages.
Okay, so when was that statement that I'm going to shoot up the house and yada, yada, yada? Sure, take your time.
And Judge, while they're looking, it's not alleged when the statement was. And not only that, it's not reported till 3 days later. Furthermore, in the reviewing the text messages that have been submitted, there's not a single text message that has that specific threat in it.
Well, I don't know. I mean, it's the state's burden to show, I don't know, but terroristic threat has to be an immediate fear of harm.
So I don't see an actual date in the offense report. I personally have not reviewed the text messages in this case, Judge. I don't see a date of the actual threat.
That's not a good thing. I mean, who knows when that statement was made? Could have been made 2 years ago, could have been made yesterday. Yeah, I agree with you, man. I mean, if you don't have anything else, then that's it. Okay, I'm gonna find no probable cause. Mr. McCollum, we're not asking much, man. We want our streets to be safe. I'm gonna do everything in my power to protect the streets, right? If I find that you're a problem, if they call back and it continues to happen, it's not gonna go well. Life is way too short to live in a 6x9 box. There are a lot of great people in life. There's a lot of bad people in life. And if you have a relationship with a so-called person that brings out the worst in you, then don't have a relationship with this person. There's a gajillion and one fish in the sea. It's not worth it to have someone rap you so bad that you make and say things that make you go to jail. It's not worth it. Do you understand? Now, don't have contact with this person because it's just not going to end well. All right? All right. So I'm going to continue bond. I'm not going to revoke your bond on this case now because I'm finding no probable cause, but just behave. It's not hard. Be nice. All right. Okay, for sure.
Morning, Judge. He speaks both English and Spanish, Judge, but he says he may feel a little more comfortable in Spanish.
I don't know if it's going to be a good one, Mr. Martinez. I'm not happy with you. I asked you one thing. I have here that you're tampering with your device. Any alcohol detected?
No alcohol protection, Judge.
What, do you know either? What?
So what he tells me in terms of the, I guess, potential tampering, he said was, the device was wet around his skin, so he used, in fact, he told me yesterday, he used a leaf blower to dry it off. That may have been one of the times it was tampering.
That wouldn't cause a tamper. Environmental factors like that don't cause something like that, and that would be such a short period of time. I have the durations of the hours on that little sticky note, and I can't remember them off the top of my head. But tampers are confirmed after 8 hours with low alcohol detected, so therefore a leaf blower would, if anything, would show a spike in tamper, but nothing to cause a tamper.
So what we have here and what I have here, your first tamper was on October 28th, and it was an 11-hour tamper. So more than likely, what we find is that people put things in between the scram device and their ankle to subvert the machine. Your second violation that we have is on November 11th at 3 in the morning, and that one is a 9-hour tamper. How does that happen?
So, Judge, the only thing I have is the violation report. I don't have any other documentation from you guys showing exactly,
The problem is that there's only,
but in terms of saying that it was for 11 hours.
I have the scram report, counsel, I can send it over to you. If you'd like.
but, and if you want to take time to look at it, but what we find, there's no cameras, so it's impossible to really look at what they're exactly doing, but all we know is that they're breaking the continual skin and device contact. And how they're doing that, I wouldn't know. Only he knows. But all we know is that the tamper is for a duration because the contact is lost somehow. Piece of paper, could be that they're using a sock, however it may be. But all we know, it's for a certain duration and that it's a tamper and it remains constant for that entire period. So the machine is not able to test his leg.
Okay, yeah.
So I'm happy to give you the device. You will stay with me now. And
I'd like to look at it and talk about
yes.
exactly what.
Yeah, I mean, I'm not letting him go.
I understand. Okay, so.
So
Defendant-
we'll give you the info now. I'm taking you into custody right now. I'll let you talk. I don't want him to go outside.
I understand. I understand.
But I'll give you more than enough time to talk.
Sure, okay. Okay, we'll talk afterwards. Yep. Sure, MAA.
Good morning. I wanted to bring you out because there's things I would like to address with you. I don't know if at the time we ordered her not to consume alcohol or illegal drugs. Let me see. One of the things that I ordered you to do was not have any contact with a Ronnie Boo Slyman.
Yeah.
And I see now that you have picked up a continuous family violence felony case. You don't have to say anything. I'm just letting you know what's happening. Now, we asked you not to do several things, and you have now violated several conditions of our bond. One of those being, number one, we ordered you not to have any contact with this person, and allegedly, you've picked up now a felony assault against this person. You picked up a felony violation of a bond condition or protective order, and you also have picked up a felony assault against a peace officer. Because of this, I'm going to now revoke the bond here that you have here, and I'm going to raise it up. I'm not going to give you a PR bond when you continue to violate conditions. I'm going to do everything in my power to protect my public at all costs. And I'm going to tell you now, there are certain people in this life, when they consume alcohol, they become funny people. They have fun, they laugh like little rainbows, gumdrops, gummy bears, and little bunnies jumping in the woods. And there are those, when they consume alcohol, they develop horns, they become the antithesis of what a person should be. And if alcohol has this kind of effect, don't use. Because that may very well be the source of all these issues. I don't know, but I'm taking a stab.
Judge,
And I hope not.
May Judge, just to let the court know, since she's been on bond conditions, she did voluntarily check herself into treatment for alcohol. So as the court knows, that, the road to recovery is long and bumpy. She's in a difficult situation being that she's originally from Mongolia, is that right?
No, Kazakhstan.
Kazakhstan, I'm sorry. Kazakhstan. She had, a pretty crazy story about getting here. This guy that the court told her to stay away from, is like one of her only connections, and he's also done some inducement to get her back over there. I understand that it was ordered for her to stay away from him, but it makes it difficult when you don't really have a lot of people to rely on, and then you have someone who's trying to basically get you to hang out with them, even though they know that it's been ordered that she shouldn't. But I just want to let the court know that she is taking steps to try to better herself and her situation. It's just she's in a difficult spot between the addiction and lack of resources.
Even if that's the case, if you know that alcohol has this effect and it brings out the worst, then don't. You already have an open case. And you know, if you have no one to rely on in this world, if you go to jail, they're not going to bond you out, then you have to think of these things when you're out there. Because sometimes, you may have but 1/10 of a second to think, oh God, if I do this, what's going to happen? If I say this, what's going to happen? Now, where are we?
Can I say something?
It's now, anything you tell me, it's going to go in this ear and it's going to go out that ear, because I know
I got you.
if I let you out, you're still going to do whatever you want to do. You don't care what we say. That's the problem. And when you come here and when we talk to you initially, we try to tell you, look, this is how we expect you to act. This is what we expect you to do. And when you do, and when you show up to court, and when you talk with Hunter, good things happen. Now, I'm telling you this for the future because I don't know what's going to happen from here on out. All I know is that you have very serious cases upstairs. And in the future, going forward, whatever may happen, whether it's a probation, whether it's this, think before you act. And if the source and the root of all evil is, no matter how bad the addiction is, if you don't, it only gets worse. It never gets better. And the older you get, the more difficult life becomes. You get older, bigger, fatter, you lose hair, life doesn't get easier. And when you get more of this, so I hope that you take the help that is offered now, because we're going to offer you help and we want the best to come out of you, right? We want the best for you. But you can't continue like this. So now, like I told Hunter, I am going to revoke your bond. I'm going to raise it up to 5,001. We'll come back in a couple weeks and see how we go forward, but I can't give you a PR bond when you pick up 3 felonies.
Judge, may I make an argument for bond amount?
Sure.
She currently has bond amounts on her felonies that she can't afford. She's indigent. That's evidenced by the fact that I was appointed to her, and also, given a little bit of her background, she's not only indigent, but, has a lack of resources otherwise. I would ask the court to consider $250 bond,
Gotta love you, Hunter. Gotta love you.
Just taking
The
it.
bond's at 2,500 now, so that would mean lowering the bond. I'm gonna set it at 5,001. We'll go forward. It looks like your felony case is set for February. You will go to felony court in February. Hopefully, you guys can wrap this up and try to get everything quick so you don't just sit there and linger.
Just ask for a speedy trial date on this case.
Absolutely. I have to give them at least 30 days for them to get all their stuff in preparation. Is it your case? Is it,
It's actually Conrad's.
Conrad's? Yeah. Okay, I guess, let's do this. Is he here? You want to talk to?
Not bad, but I can give him a call, maybe.
No, but I want to give him a head, or if you can give him a heads up that that's where we're at. I guess let's set it for early next week. Is discovery complete in the case? Wait till at least we have some discovery first.
I think it's all complete.
I think we're still waiting on body cam. Let me see that. Yeah, it looks like this looks like body cam was re-requested,
We don't even have body cam. Let's do this. Let's set it for next week, like late next week. See if we can get the body cam. If you can get it, and then we can get also Conrad to come approach, and then we can set it at that time if you want. Yeah?
Good, Judge.
All right. We wish you the best of luck, man. Take care. Mr. Williams, you are charged with driving while intoxicated. You're facing up to 6 months in jail. and or a $2,000 fine. You guys have worked out an agreement where they're offering you 9 days in jail with credit for the 19 days that you've done. I want you to understand that this behavior is just unacceptable, and I'm serious when I mean that here, we're without accountability. And if I don't hold you accountable, I'm telling you it's okay, and that you can just continue to run amok and and railroad, and it's not. We mean business. We're here to not only protect the community, but to teach you a lesson so that you understand that it can't continue, right? I don't know what happened over there. I don't need, but when you're on bond, you can't pick up a felony case. And there are consequences, and I hope that you get it, right? The other thing that you need to get also now is that this will reflect as a conviction on your record. If you're ever in a car, I don't care where you are, I don't care what state you're in, you get pulled over and you have a smell of anything funky, they're gonna probably take you in. They see that you have a prior DWI, if it walks like a duck and it talks like a duck. So if I were you, I would never, ever get into a car, even if you've had a sip of alcohol, a toke off of a joint, you smell anything funky, I'm telling you, you're gonna go down. And what we're doing today, from now on, you're facing a minimum of 30 days in jail. So like I'm saying, I'm doing this, believe it or not, to help you. Because we want to see the best in you. We want the best from you. Be better, do better. You're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. It will go on your record. It will be there forever. I have to suspend your license. I am going to suspend it for 180 days. There is also a mandatory suspension, a DPS surcharge. I will waive that for you now. But I want you to understand that if you come back a second offense, you're looking at a minimum of $6,000 in fines and fees, not to mention another court cost of around $600 to $700. So you pick up another DWI, not only is a minimum 30 days, but you're looking at probably around $7,000 in fines and fees. Just one button on this phone, $30, wherever you want to go in this, don't matter where you want to go. That's what you need to do. How do you plead to the offense? Guilty or not guilty? I'll find you guilty. I will sentence you to it. You're going to walk out of here. You're not going to owe anything, but don't come back. All right. Thank you, counsel. All right, guys. Good luck. Yes, sir. Yeah, thanks.
This is Brian Martino, the judge.
Come up. Hey. Hey, Steven, that dude in the blue jacket. Grab homeboy. Did he just now get here?
He got here probably about maybe 15, 20 minutes ago.
I don't know what I'm going to do with you. All I know is I want the truth. I want you to raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I haven't decided what I'm going to do with you, but I want the truth. And if I think that you're lying to me, I will revoke your bond and I'm going to put you in jail. Do you understand? If you're honest with me, it will go a long way. I promise you. Why did we have the tamper?
La verdad no tengo la idea qué pasó. the,
Yo he estado
because I don't know
portándome
what
bien,
happened, I've been behaving,
trabajando
working.
y no he hecho nada más que concentrarme en eso, trabajar,
I've only been focusing
portarme
on that,
bien, no he tomado
work,
más alcohol.
behave properly. I have not drank any more alcohol.
To know about the tamper and whether you put something in your leg or not. Be honest, Mr.
No
Martinez.
sé nada. Lo que sí a lo mejor pudo haber pasado es cuando le fui a cambiar la batería, que ya hice un reemplazo de batería.
Like what could have happened, I didn't put anything in there. What could have happened is whenever I exchanged the battery, I've done it once already.
Guys, keep it down, please. Did what?
They had contacted him to have him change the battery. I don't know when that was, in that time frame. But what he had also told me is that que trabaja como pintor.
Yeah, I do painting, I do walls, sandy, I do flooring.
No, I don't give a rat's ass what you do in this life. I want to know what happened with the tamper because they're telling me the device lost contact with your skin.
And that's what he's
All
trying
I'm
to-
asking for is the truth.
That's what he's trying to
Truth
explain.
shall set you free.
No he cometido es bloquearlo, no lo he hecho.
I haven't done that, I haven't blocked it.
Puede hacer el polvo que quede en mi trabajo, puede hacer otra cosa.
It could be
Pero
dust that's
yo
sticking
no-
from work. It could be
Yo
something
no lo he
else, but
bloqueado.
I have
Me
not blocked it.
baño, me acuesto a dormir,
I take
me
a
levanto a
bath,
trabajar todos los
I go to
días.
sleep, I wake up every day for work.
I'm sorry.
I haven't touched anything.
I will tell you that I don't believe you.
No le creo.
These devices are supposed to remain on your skin. The device remains in constant contact with your skin. And when it comes out of contact,
No tiene contacto.
and when it, just listen, when it comes out of contact, it gives us an alert. And when it remains out of contact for a certain period of time, that's when we know from pretrial where they tell us that it has not had a continual contact with you for however long it may be. That's why the first time was 11 hours, the second time was 9 hours. I wasn't there. I have no idea. All I know is that it lost contact. And this doesn't poof, magically appear like a fart in the wind. It has to be there from some purpose. It doesn't magically.
Judge, those machines are not valid. I've explained the situation before. I had the exact same situation in court 8 where my client had the scram and she also had a portable device. In the exact same time frame, it says she had a .157.
Hey,
Also,
but there, you're dealing with a positive result versus here, we have a temper. It's something different.
It may be different, Judge, but just go to the fact that they're not perfect. It's not a perfect science behind it, Judge.
I have hundreds of other people on these devices and they have never had any issues. You know?
Es un poquito, lo tengo un poquito flojo, eso sí, que eso fue cuando me lo pusieron para atrás.
It was a
Y no lo he
little
tocado
loose, that's
para
the
nada.
only thing, but I haven't touched it. It was loose from the beginning.
Now it's flojo.
No, aquí
Judge, he's not changing the story. The original question was
Honestly,
what happened. He's explaining exactly what happened. He's explaining what happened. Your specific question was whether he put anything in there. He's saying, I did not put anything in there. He didn't. He already knows that you told him if you tell me the truth, everything's gonna be fine, and so there's no reason for him to lie about that. I've talked to him 4 times now, and he's always said, no, I don't know what it is, maybe it's the portable, I don't know what it is, but, you know, that's why he said it gets wet in there, and I used a blower on it. It's like, I don't know.
No sé.
I mean, what if we also have him do the portable? I mean, I don't know what to tell you, Judge. I'm trying to remember why we ended up getting, why he had to scram in the first place. Was it, I don't remember the case.
I mean, I'm not going back on the why. I mean, I'm ready to just revoke his bond because he's not
revocar la defensa porque
I understand, Judge, but
pero
he didn't test positive for alcohol.
por alcohol.
He's never had a bond violation
Tenía una
before.
violación defensa previa.
When I told him you have to come to court because of potential bond violation, he was here to explain. So it's not like he's hiding from anything. I'm in constant contact with him. I think I would appreciate if we could just keep going and see how we can resolve this case, Judge. And again, he tested negative for alcohol and drugs.
Salió negativo por drogas y
Negative.
Say, what do you think?
Judge, I mean,
pues
I just think it's important to note, and you already know, there's been 2 tampers. One occurred at 3:00 in the morning. I think that's also relevant information. I'm not sure what hours this individual works, and I understand it has to occur over a certain period of time.
que tiene que ocurrir sobre cierto
but-
tiempo, pero
I don't know. I do see that he also, I think there might have been something about a prior DWI in Tarrant County as well. I'm seeing that on the history, but I'm looking into it right now, Judge. I don't want to formally say that he's the
Which
one
may have been the
convicted.
reason why.
That could have been the reason why we had to scare him in the first place.
How long ago was that?
Looks like 2019. If I run his NCIC, I'm not
It
seeing
says
a
unknown.
disposition, right?
Thing is, the
I
thing
mean, that
is,
disposition in 2019 with Tarrant County, Judge, so we don't know what's going on with that.
what I'm going to do now is I'm going to alter and amend your conditions to give you a curfew. I don't want you out in the middle of the night. And I'm gonna tell you, if you ever have another violation with me again, I don't give a rat's behind what your excuse is. I will put you in lockup. I don't care what you're doing. I don't care where you're going. I don't care what your excuse means absolutely nothing to me. I don't care about excuses. I care about actions. You either make the correct action or you make the wrong action. And when you have the wrong action, there are consequences for those actions. You're old enough to know about this. So I am now giving you a curfew of 9 PM to 6 AM. You go out past that time, then I'm going to put you in lockup. And I don't care what you say. I don't care what you're doing. Do you understand?
Yes.
That's it. One more violation
una violación más.
will stay with me. If you need to go get that machine changed out today, do whatever you need to do. Because I will not entertain any more excuses. And because the tamper is at 3 in the morning, who knows what is going on, but nothing good happens at that time. And that's what scares me. If you're out and about and you're tampering at that time, something no good is happening. You will not get any more benefits of the doubt. All right. That's it. Hey, no tolerance.
I understand, I appreciate that.
Yes, you do.
Yeah, what? He has a GPS as well already, Judge. He has GPS and.
Curfew on him now, because I don't think he doesn't have a curfew now. It goes on now. All right.
Okay, so,
No, he does. He
Yeah.
does.
What is it?
it has been no violation, right? It's,
So he has a curfew.
Yes,
No era de
sir.
estar en casa.
Where was the tamper at 3 in the morning? Can you tell me?
Puede decir.
I can't at this moment. I can get the.
Look, take your time. Get the coordinates. I'd like to know if he's at home, all right? If he's out and about, I'm gonna have an issue with it. Look into it, and then I'll,
Not an about with that, they would have filed on the same BDR and.
you know how many muck-ups we have there? Never take anything for granted. Never take anybody's word until you look into it. Never. Until you do it and you can 100% confirm yourself. So please look into it.
Yes, sir.
I'll give you a normal reset for now,
And then she'll come out.
but now the curfew is now and anymore,
Sure,
that's it.
curfew was in place, so it's-
I don't know, and it was never mentioned, and so I didn't even see. It's a curfew.
But I guess it wasn't mentioned because there was no violation on it, but we'll find out.
Okay,
Thank you, Judge. I'll get a reset.
Joe,
Yes, sir. We need an interpreter, Joe.
come up.
Well, this has very valid explanations that I think the court will want to hear in the situation. It's a very unusual situation.
What time does court start? Mr. What time did you get here?
I didn't have to come today. After the 4th, I was supposed to communicate with my lawyer.
I ordered you to come here today because you picked a new case. You are on bond for an assault. You now have picked up a new assault. You are now facing another year and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Complainant and the defendant a relationship. On 11/27/24, officers were dispatched to an assault in progress in Harris County, Texas. Officer met with other officers who had already detained the defendant. The officer spoke to the complaining witness, who stated the defendant pulled her hair at the house and that she felt pain. She stated that they had been driving down Westheimer and the defendant attempted to take her purse that had a flash drive that had fraudulent scam material on it. Complaining witness said the defendant was trying to scam San Jose gas, oil, and the information was on the USB drive. Complainant stated that they started to fight and she scraped her hand on the purse and felt pain. Complaining witness also stated no threats were made and the suspect did not put his hands on her. Defendant stated they were arguing in the car and the complaining witness slapped him twice and scratched him. Defendant stated he felt pain. The witness stated she worked security and she saw the traffic was backed up, so she drove up and saw the complaining witness and the defendant in a stopped car in the street. She said she saw the complainant and the defendant fighting. Complaining witness was trying to exit the vehicle and that's when the defendant pulled her hair. Witness stated the complainant exited and ran across the street and called 911. Officers observed blood on passenger window where complaining witness was sitting. Officers also observed complaining witness to have injuries to both hands.
Your Honor, no, the one thing I just wanted to point out was more on the dates, in that apparently he thought that the new case was set for December 5th. On this document, it refers to December 5th, but down bottom, it looks like then it was ordered that he appear at the court's next docket on Wednesday, December 4th, because the original case that we had been here for, the first case, his appearance was waived on that case. So he got confused and thought it was waived, and I think
He was supposed to appear because of the new case that he picked up. So regardless whether he comes at 8:30, he comes at 9:30, I don't think I've ever taken someone in for coming in at 11:30, for coming in at 12. But I do have a problem when you pick up a new case.
yes, sir. And
It's alleged here that you have assaulted this person, and they have now provided me with enough evidence that I'm gonna find probable cause that it occurred. Joe?
Your Honor, the only thing I can say is, the client has vigorous defenses, and obviously that's not the appropriate point to point out. But, I don't know, was the complaining witness out on probation at this time, or because she herself was under
Well,
the legal.
all I know is that,
Very
is
serious.
it 2 times that he pulled her hair, or was it just 1 time? It sounded like it was.
just a one-time, Judge.
He was trying to prevent her from, she was gonna go out with the moving vehicle, where his position was. He was trying to keep her from hitting her, from going out of the moving vehicle.
I didn't hear anything about that.
I believe what happened is she called and reported this afterwards. They left the scene and then she called, phoned him and reported it afterwards.
So is she trying to jump out of a moving car and he's pulling her hair to keep her in? Well, but then the witness sees them outside of the car arguing and then he pulls her hair outside of the car.
I heard that, I did hear that,
So
Your
the
Honor.
witness saw the defendant and the complaining witness inside the vehicle fighting. The witness tried to get the complaining witness out of the motor vehicle, and then the defendant
Picked up a new
pulled her back
case.
by her hair.
Like, are we supposed to be happy you're on bond for an assault and you pick up a new assault?
Confianza por assault, que no, pasó una vez assault.
Yo no le había dado nunca a la persona que
Well, now is, I mean,
I would never hurt somebody that I'm with.
por favor, me refiero que diga su señoría. Ella es menor, ella ahora mismo está en la prisión.
She's, my girlfriend, she's right now in, jail. She has,
Porque ella está ambiciada en las drogas.
she's, has problem, she's, drug addicted to
Yo
drugs.
quiero que ella lo
hey,
hospitalice.
I want her to be
Yo soy la-
hospitalized,
you,
The only reason that was relevant, Your Honor, if I could help him out, is that he did tell me beforehand to help the court and the system, is that she has been his girlfriend for many years, and that he has one child he supports along with his mother, who's here today, and he works as a driver, and he does support them all. But she does have this problem with drugs and has this pending case. He himself suffers from depression and diabetes, but he does manage to work in order to support them all. But these are just things that maybe the court could consider, because it would be a big hardship for them to lose the income. Now, he would agree to any kind of additional controls in terms of staying away from her, but you know, maybe 200 feet away or things like that. Because she's not living with them, the child is not hers, it's from a previous relationship that he supports. But they're actually 2. One is 7 years old, one is 7 years old, and the other one is 3 years old. And so we're talking some very fairly young children that's in his custody. Now, his mother has been helping maintain him. She's back there on the second.
The complaining witness is currently in jail. I believe in Harris County Jail. I'm
this
trying to figure
complaining
out what
witness?
for. Yes, Judge. I'm just trying to figure out for what, all I see is an out-of-county charge, so maybe there was a warrant.
Give him a cause number?
So it shows up kind of weird. I have like an out-of-county cost number.
It's okay,
but
just-
I don't know if it will show up.
Is it a 2? Is it a 3? What?
No, it's like OOC.
No, that's,
Yeah.
huh?
Two sides on the side of the top.
Yeah, you can look up, yeah, it is.
Wants to.
0326
Hold on.
Austin.
0326?
8412.
So it was Austin, Your Honor.
No, it didn't pick up. 0326 8412?
Possession of, substance.
No, I didn't get it.
It says that she's currently in Harris County Jail as of 11/27.
Do you have a cause or do you have a spin?
It's not, the spin number is, it's 03268412, it doesn't come up on here, 0326.
268412. That's the spin I have.
No. For me, it's not coming up. Let me try this. Maybe 3. No.
It looks like she was booked in, November 28th, but that's everything I see.
Booked in what day?
November 28th.
Yeah, so what happened if they got arrested together?
That's all I see. So it's gonna be another.
She's got,
See or no?
Yes.
she's got a less than a gram case wherever.
Okay.
So she must have had an open warrant for a less than a gram case as well. Mr. Tujaquez, all I asked you to do was be safe in my community. You've now picked up a new case. I'm not gonna let you go. You picked up a new assault. Doesn't matter who it is, doesn't matter where it is. We ask you to behave yourself. And when you pick up a new case, that's not a good thing. And if I let you go, that is telling you it is okay to do what you're doing, and it's not. There has to be consequence to action so that you understand we mean business. If this person is like that, then you know, or you should know,
Yes.
not to associate yourself with this type of person. Do you understand?
But please, my family depends on me.
Then this is what you think of beforehand. You don't think about this after the fact.
But I didn't do anything. I wanted to help her.
I'm not gonna talk to you about the case. I'm not gonna know. Now, I will tell you this, that I had already revoked your bonds, and I was gonna set them both at 10,002, but I won't do that. I'll entertain a lower bond with you, Joe. I mean, what do you think is appropriate? I want you to understand that I'm going to take you in because I want you to understand that public safety is my number one concern. That's it. As a courtesy for your lawyer, and because of what you're saying, I will not set it as high as I was going to, and I will entertain a lower bond. But you picked up a new assault.
Donna, would you consider $1,500?
Faith, what do you think?
Judge, I'm just gonna argue for a general $5,000 bond. This individual is told obviously not to pick up any new cases and pick up the exact same kind of case. Well, not bond case.
All right, so what I'm gonna do is I'll split the puppy, okay? And on the new case, he's at 5,000 now on the old case. I'm gonna revoke that PR bond. I'm gonna set that one at 5,001. And then on the new case, I'll do it 3,501 as opposed to 10,002 on both of them. And that is, Joe, you know, I hope that you now understand that we mean business. And no matter what the excuse, no matter who you're with, you pick up a new case, there are consequences.
Yo le prometo que usted no va a ver más nunca. Problema, yo nada.
Promise I won't cause you any more problems. You won't see me for something like this again.
I hope you show back up to court.
Es serio, ¿no? Es serio.
Stay in contact with your
Sí,
lawyer,
claro, sí, claro.
Of course.
and from now on,
De ahora en adelante.
as a part of your,
Por la parte,
Le pido una disculpa
don't.
porque yo el día 4 no tenía mi corte.
Jaques, no habla. I want you to listen. I don't want you to have contact with the complaining witness in this case. I do not want you to be in possession of any weapons. You are also not to have contact with the complaining witness in the first assault case. If you pick up a third case, I am telling you now, I will go absolutely bonkers on your bond. Do you understand?
of course.
The only reason I'm making the bond as low as it is now is because of Joe. Otherwise, your bond would be at 10,002. But as a courtesy, but I will have absolutely no qualms whatsoever if you pick up a third case. Who's the complaining witness in the first case?
I think he's just an employee of a business at a car dealership.
Okay, all right, goes with you. All right, okay, Joe, we'll talk soon. So, hey, he's gonna auto-populate tomorrow. What? Oh, yeah, oh, shit.
Can you bring him over here?
I didn't realize it was a family member. I'm sorry, Stephen, I forgot there's a mow-up that we need to enter in. Come on back.
Are you gonna speak to him?
No, Joe, sorry, Luis. Sorry, Luis, I forgot to do the protective order. Let me see. Has it been entered?
It's in there,
All right, here we go. Mr. Tujakis Palomino, I'm now entering in a magistrate's order for emergency protection. This is a court order that identifies Ms. Ramos Savarit as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you get out of jail and if she should contact you, if she calls you, do not answer the phone. If she calls you from an unknown number and you answer the phone and it is her, hang up. If she texts you, do not reply. If she comes to your house, do not answer the door. If she gets a hold of you through social media, do not answer. You're the one. If you violate this protective order, the state can and possibly will file a violation of a protective order. You violate these conditions, I can have a hearing to hold you at zero bond. Zero bond. And I will do it in a heartbeat to protect every person of this county. Do you understand? Are you sure? Okay. All right. Thank you, Stephen. Sorry.
You can sign over here, but if it matters.
Janae. Hugh brought.
And the CRS recommended thinking for a change.
Okay. Really? Okay, I want to do it. No drugs, no alcohol. I'm telling you, you pick up a new case, I'm going to lose it. I'm seriously going to lose it. What happens if we lose it here? Your bond right now is at 7503. At some point, someone's going to stop ponying the money for you, man. You got to realize this. So, no weapons, no contact with the complaining witnesses. Yeah. And then what happened with the trespass? Where was that?
I think it was a trespass of a vehicle. Yeah, trespass of a motor vehicle.
Say it again?
Passenger in a stolen vehicle.
Oh, right. All right, so no contact. Did that person get arrested?
I believe so.
So no contact with the complaining witness, and then no new law violations. And what are you doing with yourself these days, Mr. Smith?
I work at a crush shop. Paint and body.
Don't use. I'm going to test you. If I find that you're using, guess what? Right. Like to send it for a drug test right now as well. Okay. So, I'm going to alter amend, add thinking for a change. No drugs, no alcohol. I'm going to test you today.
So have him report back to court, judge, after his drug test?
Yeah. Well, it's 11 o'clock. Let's set it for later this week. Okay. And then if he tests positive, I want to know. And then I'm going to give him, if he tests positive for something, I'm going to give him time to clean out the 45 days. And if he's not, then you know how it goes. That's it.
So do you want to roll up to tomorrow, Judge?
No, just give a couple days because I don't want him to lose a job or anything.
Okay.
Okay. All right. Or early next week, but I want to send him now.
Judge, how long do you want to extend the probation for?
How much time?